Good afternoon, everyone. This is Rajiv Khanna from immigration.com, the law offices of Rajiv Khanna, PC. This is not an attorney-client privilege telephone call. Now, does it create a relationship like that? When you log into the call, you hear the disclaimers. That said, I just want to make sure you guys can hear me okay now? Hello? Can you hear me?
Yes, we can hear you.
Okay, perfect. Perfect. I'm going to start the conversation now. Just stand by.
The conference is now in presentation mode.
All right, folks, let's get started. I did not spot too many frequently asked questions today, but I'm going to go over the ones I did think of frequently asked questions. I didn't have a lot of time before I got started, but I did review the questions briefly. The first frequently asked question was about change in job roles while green card is pending. While this is a fairly lengthy topic, I wanted to cover the questions that were asked and perhaps a little bit more generically. Oftentimes, this becomes more of an issue when your green card is in the process under the PERM process. For categories like national interest waiver or a category like EB1A, it may not have much significance. And also, under any category, once your I-140 is approved and I-485 has been pending 180 days, you can then, of course, use something called Ac21 Portability. Ac21 is American Competitiveness in the 21st Century Act. It was a law passed by Congress to give us some relief from long pending green cards. So once your I-140 is approved and 485 has been pending 180 days, you can change to same or similar job with any employer. Okay, I am addressing that part where you are in the PERM process and all of a sudden they have decided, your employer has decided to give you either a huge promotion or a change in jobs. What happens then? Okay, so we're going to address that part. And there were some other interesting questions here that I thought I should mark as frequently asked. Let's see what the questions were. I-140 has been approved for almost 2 years with the priority date of 2018. If I change jobs or move to another plant, same employer needs H-1B amendment. I understand. But how about approved PERM I-140? Let's stop here and take a breath. This is a question that should be addressed by our lawyers in the very beginning. So when we start a green card, our first question is to the employer, is this job subject to relocation? So for instance, if you are with a consulting company, if you are with Deloitte, for example, you're probably changing clients every 6 months to a year. What do we do with your green card? So for jobs that are subject to relocation, the labor certification, the PERM application is prepared by lawyers in a way that allows you to move without causing any harm to your green card. So change in location in a well-prepared labor certification is never a problem. Okay, let's cover that part first. Now, another interesting thing is, let's say I did your PERM for Columbus, Ohio. The company has a plant in Dallas, Texas. Now they want you to move to Dallas, Texas. Is your green card gone? And the answer is maybe not. If they want to relocate you back to Columbus, Ohio, as and when you get your green card. So because the green card is a future job, if you will be relocated back to the same job and job location, your green card could potentially still go forward. Okay. H-1B, of course, has to be amended. So to answer your first question, I would have to say first thing you should look at is your PERM petition prepared for you to be able to move? And second, will they relocate you back to the place of employment stated in the green card process after your green card is approved? Okay. Second question is, if I completely change my employers, new H-1B is approved, is it valid for another 3 more years, even if my first 6 years are over? And the answer is yes. Once your I-140 is approved, you have the right to extend your H1 on 3-yearly basis going forward. If the I-140 is not revoked for 180 days after January 17th, 2017, even if the I-140 is revoked after 180 days, your right to extend your H-1B beyond 6 years is not taken away. Okay? So your question was, if I change my employers, in the new H-1B approved, does the new employer have to get a new I-140 approved? The answer is no. So when you move to a new employer, the fact that your I-140 was already approved and stayed approved for 180 days, even if the old employer revokes the I-140, you still keep extending your H1 with any employer, whether or not they have filed your I-140. And of course, they can't just file the I-140, they'll have to go through the PERM process. Now, there is a law in the books that says you must apply for a green card. If the dates become current, they won't give you 3-yearly extensions. I think they'll give you 1-yearly extensions. That's my reading of the law. I'm subject to correction because I haven't looked at this relatively tertiary issue of law. So it is advisable to start a green card with the new employer, but it's not a panic situation. You can take a little bit of time if your dates are still away. Okay. And also, the renewal of your spouse's H4 Ead, she gets the same benefits as you do. So if your I-140 gets approved, stays approved for 180 days, you get the right to keep extending your H1B beyond 6 years, and she gets the right to keep extending her H4 Ead, even if the I-140 is revoked. Okay? Then what happens if the priority date becomes current and the new I-140 is not yet approved? Can I file 485 right away? No, you cannot. Because the old job is gone, you can no longer file the I-140, I-485 until another I-140 is approved. And hope that dates don't retrogress. Correct. So you've got the question right and the answer partly right. Absolutely. You cannot file a 485 because the old job is gone. You get a new I-140 approved, and if the dates are current, when the I-140 is approved, you file the 485 through the new employer. Last case, if I stay in the same job with current approved I-140, dates become current. Must one wait 180 days? Yes. Ac21 portability does not occur until 180 days. You don't have that right until 180 days. Okay. So, of course, it's my pleasure. Absolutely. You don't have to thank me. Guys, any follow-up questions on what I just discussed, press *5. No new questions, just follow-ups. *5 on your telephone, please. Okay. Let's go on to the next frequently asked question. Okay, which one? I think there were a couple more. Oh, yeah. This one is H1B working for multiple clients through the same consulting company. Of course, that's okay, but there are some conditions. I'm on H1B with a company. Can I work for 2 different clients under my employer? Do I need to file an amendment? Does it need to be approved before I start working on the second job? Or can I work after the new amendment is filed and is just pending? Well, these questions seem very simple, but if you think about them generically, they actually contain a lot of subtexts. So for instance, let's examine, let's say you're working for a large company that has, let's say Rackspace. Okay, that's where we host our servers. So Rackspace has thousands of clients and they're a hosting company. You are working on either with specific clients or specific groups of clients. But can you be said to really be working for clients? Because you are working from Rackspace's either remotely or at their premises on servers they are hosting, even though the projects are for different clients. So you could have a situation where all work is performed either from your home or from your employer's offices. I think there is an argument here that says you should not have to do an amendment, especially if this situation was covered in your H1B filing. So I'll give you an example. I have a company here locally in DC. They have multiple contracts with the 3 state governments, DC, Maryland, Virginia. Okay. They specialize in a certain area of enterprise resource planning. So they have multiple projects, multiple contracts. When I hire a person for them on an H1B, I make it clear that my guy or my client could be working for any number of projects at any number of times. We have floating projects, but at all times they'll be working from our offices. So in those cases, amendment is not necessary. But let's say you filed an H1B for a specific client. I will be working for the DC government. And then then a new client is acquired. If the job remains the same and you're still working from your employer's premises, I don't think an amendment is needed. But if the job description changes because you acquired a new client, or if you have to now work from their premises, I think an amendment would be needed, even though it's in the neighborhood. So to answer your question, you asked a simple question, but the situation can have many permutation combinations that require a little bit more analysis. So can you work for 2 different clients through the same employer? The answer is yes, if your H1B covered that situation, that you could have multiple clients, and you are working either from the client, from your consultancy's premises or your own home for all end clients. I still would not want to make a sweeping generalization. I would very strongly recommend, Rajeshji, that you speak with a lawyer about your situation. Whoever is doing your H1B, just talk to them and say, this is the situation, what do you want us to do? Okay. Now, how soon can I start working? So let's say, taking the example of our DC client, they've got DC, Maryland, Virginia going. They hired a guy for DC project, but Maryland wants them to move to, I don't know, Annapolis, which is outside the DC metro area. So if they want them to move to Annapolis, I would have to file an amendment, and they can move to Annapolis as soon as the USCIS receives the paperwork. So they don't have to wait for the approval. As long as they are maintaining their H1B status, they can use H1B portability. Okay, I hope that answers your questions. *5 if you have any follow-up questions. No new questions, only follow-ups, please. I'm beginning to get my doubts. I don't even know if you guys can hear me. Let me make sure. Okay. Oh yeah, here is it. Okay, there's a hand up. That is good. From Pennsylvania, okay. Pennsylvania, go ahead. I can hear you.
Yeah, hello Rajiv. I'm sorry. I had a follow-up question on the question you had, but I think I was late by the time you had started the question, so I didn't want to interrupt.
Okay, no worries.
So in case that you like I was saying, if you change job and the old employer decides to withdraw, they cannot revoke the I-140. But is there a way that if they withdrew the I-140?
Well, that issue just came up today. We were going over the spreadsheet of the employees of a company we've been representing for 20 years. And they had hired, I think, 11 or 12 new people. And all of them didn't know if their old I-140s had been revoked. So I was discussing with the team. I don't get into these tertiary details. My job is, you can think of me more as a system architect rather than a coder. So I don't really know exactly what they do, but I understand that if you have the receipt number for your case, you should be able to enter it online and see what the status of the case is. How reliable it is, I do not know, but at least you should be able to find out. Another thing you can do is you should file a Freedom of Information Act request with the USCIS. You can do that online. It doesn't cost anything. Ask them for a copy of your immigration file.
Oh, I see. That is interesting. So that would be same in case of an H1B petition as well, I-129, right? You can always
absolutely. Do a FOIA request. Absolutely. At some time, I'm going to have to sue the government because this is an absolute ridiculous policy where I am the employee. I am as much interested in that case as my employer is, and I get no information from the government. There's got to be some way to get this done right. So, so far we've been, even in the lawsuits, we've been very successful because we've settled about 8 lawsuits against the government in the last 6 months. The simple reason is they have so much garbage in their system. It's crazy how many problems they have created unnecessarily. So this is one of the examples where you should be able to know where your I-140 is revoked. You should be able to know where your H-1B is revoked. So, but do a FOIA until we can straighten this out. That's what we are stuck with.
Okay, and could you just repeat what is the website or
Yeah,
the
it's
where we can
just
ask for this request?
there is an act. I think in India it's called Government in the Sunshine Act. In USA it is called FOIA, Freedom of Information Act. Freedom of Information Act, FOIA. So if you just type USCIS FOIA, it brings you to a portal where you can open an account, submit your request. By the way,
I'm relying on the check status like you said.
yeah, by the way, FOIA and Privacy Act requests are very closely related. They're almost the same thing. Some technical differences, but Privacy Act is basically government, give me all my information that you have. Whereas FOIA says, give me all the information regarding me that you have, not only just my information, but like what the employer filed for me. A lot of that they can give you. Okay. So go ahead and file a FOIA/Privacy Act request. And by the way, you can do a FOIA request with any government agency, state or federal. Okay.
Okay, I see. Interesting. Okay, so because I was just wondering, in case the employer does not decide to withdraw the I-140, would the 485 still be possible to be filed in case you are still going to the new employer?
No, because the I-140 is specific to the job that was the subject of the I-140.
Oh, so 485 will ask for like a bona fide or something from the employer that has filed the I-140.
Absolutely.
Okay.
All right.
Okay.
Good luck.
Yeah. Sounds good. Thank you.
You're welcome. Bye-bye. Okay, so this one is done. We have no other questions on this. So we did the multiple clients thing. Now, this is another interesting one. I added a couple of things to it. Taking unpaid leave during the COVID time, status, maternity, paternity, all these issues come up very frequently. Let's begin with the question that is asked first. I'm on H1, wife is on H4, had a baby, congratulations, 6 months ago. Company gives 2 weeks of paid leave, 6 months of unpaid paternal or sabbatical for all employees of newborns. Can I request a 3 to 6 month unpaid leave now without affecting my H1B status? In my opinion, yes, you can. So in a maternity-paternity situation, taking unpaid leave of absence should not, and I use the word should because I'm not aware of any definitive stated policy by the government, but I think you should be okay. And if they give you trouble, that's what the good Lord made the courts for. You just go knock on a door of a court, let them explain to the judge why they think you're not allowed to take care of your baby. Okay? So the answer is yes. I think you should be okay and it should not affect your H-1B status. Now, some of the questions that are being asked, and further up, there are questions asked about furloughs. And I'll address that issue, but very briefly, there is no such thing as furlough on an H-1B. The employer has to pay you your full salary. And if they put you on furlough, you complain to the Wage and Hour Division of the Department of Labor, your salary would have to be, your back wages will have to be paid by the employer. And that would protect your status as well. Okay? So those were the 2 or 3 areas that I felt were important to be covered for unpaid leave. Remember, unpaid leave is not illegal, but unpaid leave is illegal when the employer insists you take it. That's just a form of benching. Don't be a party to something like that. If they say, oh, we are going to generate your pay stubs and not give you any money or take cash back, that's fraud. Get away from that as quickly as you can. Okay? *5 if you have a follow-up question on this. *5. Okay, let's get started with the non-frequently asked questions. See how many we oh, there is a question. I messed something up. Let's see, what did I do wrong? 1 second, guys. Okay, it's easy to mess these things up. All right, there's one question from area code 412. 412, where are you calling from?
Hi, I'm calling from Los Angeles, California.
From LA. Okay, sir. I can hear you. Go ahead with your follow-up question.
Yeah, the question I have is basically the employer is calling back in July and they're reducing the salary by 25%.
Okay.
So the new salary is getting reduced from level wage 4 to level wage 3. So do they need to file an amendment?
They do need to file an amendment. When they drop you down below the prevailing wage at the level where they placed you, in my opinion, they have to file an amendment. No question about it.
Okay. But if they're saying they might be only for 2 months or 3 months, then they will.
They still have to do an amendment. Unfortunately, H1B rules are delicate, finicky, flaky, weird. You have to follow them completely. Okay?
Okay.
Good luck.
Sure. Thank you.
You are very welcome. Okay, so back to the first question. Filing I-693 for a derivative beneficiary. I have no idea what I-693 is. Is it some kind of a waiver? I don't remember that form. So I'll tell you generically what I know of medical-based grounds for keeping people out of the United States through green card or even through non-immigrant visas. So if you have a contagious disease, AIDS, tuberculosis, now COVID, government can choose to keep you out until such time as that situation no longer is a danger to US. So for instance, if you've been taking tuberculosis medication and you're no longer contagious, you can then come. The second form, which is what you're talking about, autistic or people who are schizophrenic, as long as they're taking their medication, they're harmless. So there, the rule is generally that if they don't pose a threat of harm to US persons or property, they'll come to the United States. So that answers the first part of your question. I don't think it's going to be a problem. Now, remember, there's a new ground called public charge. So under that, the government could question who's going to take care of this person if they have any medical issues. How are you going to deal with them? They could ask those questions. But if you're making enough money, etc., you should be able to overcome those issues. How do you add derivative beneficiary to an existing case? If you have an approved I-130 petition and the file is going through adjustment of status, you can contact the USCIS customer service. But if the file is going through consular processing, you should get an NVC contact. They'll send you some forms to fill out. You can contact NVC and ask them the procedure for adding a person. *5 if you have a follow-up question. Okay. Next question is G4 to F1. So G4 is one of those not multinational. What do we call them? International Monetary Fund, World Bank, UN. They're not called multinational, something else. So in any case, these organizations, their employees get G4 visas typically. And the question is, if I have to go from G4 to F1 while within the United States, I-566 needs to be filed and cleared. That is true. And you file the I-539. But can I start school while this is going on? Well, this is a little bit more tricky than just that. The usual rule is, and somebody else has the same question further down, the usual rule is, this is what I remember. You can double check this. because this government changes its mind every few hours. The usual rule, as I recall, is that if the underlying visa from which you are going to F1 allows you to go to school, you should be able to go to school while the F1 is pending. So if you are on example on H4, and I think H4 allows you to go to school, as I recall. So if you filed from H4 to F1, you should be able to start school. Please double check this with your school. That's my understanding. Similarly, if the G4 allows you to go to school, you should be able to go from G4 to F1 and start while the F1 is pending, start school. That's my understanding. I haven't specifically researched this issue. I think I'm right. Double check with your school. The school can also call the USCIS or the SEVIP people and see if they have more information on that. Okay. One thing that I wanted to point out, this is G4. Oh yeah, I wanted you to remember one of the problems is it can be more than 4 to 6 months. So what then happens is that by the time they are ready to approve your F1, if you have not yet joined the school, your I-20 has expired. So schools are actually issuing rolling I-20s for these cases. So double check again with the school what their plan is in case you're not able to get your approval within the time on the I-20. Okay. *5 if you have a follow-up question on this. *5. Okay. This is from area code 470. 470, where are you calling from?
Hello, I'm calling from Washington, D.C.
मैडम नंबर आपने तो 470 रखा हुआ
काफी घूम के ना पहले Atlanta for school and then now in DC
of course
with the World Bank. So the thing is that I'm for sure on G4 dependent visa. You're allowed to go to school. So I've been trying to get in touch with immigration lawyers, but even the World Bank, even the school is unclear if on a primary G4 I can start
I'm pretty
school.
sure about it, and I think where did I see this information? I'm trying to remember. I'm pretty sure I saw this on the USCIS website. Okay. There are two places you should look. One is look under the F1 section itself. And second, if you go to the policy manual, which is under legal resources, look at their policy manual. It's in one of the two places. I'm pretty sure it's in the F1 section. Because before this policy was never clearly enunciated. And I saw that policy and I was like, huh, that's interesting. Didn't know that they were interpreting it like that. So yeah, double check it there, ma'am. You should be able to find it there.
I'll do that. Thank you so much.
Oh, you're very welcome.
Really helpful.
Absolutely. And you can share it with your school also. That might help them ease you into the school while the F1 is pending. Okay?
I'll do that. Thank you.
Good luck. Okay, folks. Next question is about cross-chargeability. So this has several complicated issues, which I'm not sure I can answer because remember, I don't deal with undocumented people's cases. So I'm so sharply focused on legal immigration that I don't have a lot of knowledge in political asylums, refugee status, DACA issues. It's just, there's only one life. There's so much you can learn there's so much to do even in the legal immigration side, and that too with a focus on business and immigration. So some things I do not know. You said she came to US as a baby in 1992. See, there's a different set of rules for people who enter legally and people who enter illegally. So I'm not going to comment about her status. I don't know how that plays out. And I also don't know how it plays out in cross-chargeability situations. If status is not an issue, assuming that, which is an assumption, I don't know for sure. Definitely, if you get married, you are entitled to use Mexico, her country of birth, as your country of chargeability. And if Mexico is any faster, I'm not sure it is, because remember, Mexico, Philippines, China, India are always backed up. Double check that. If Mexico is more advantageous, you can definitely cross-charge to Mexico. With two caveats: I haven't researched the issue of entering without inspection, and I haven't researched the issue of marrying somebody who are not entitled to adjustment of status themselves. So that said, my answers are going to be necessarily limited, but I hope to at least give you some context which can then spur you to look for more information elsewhere. Can she move to an H4? Well, the problem is, if she has accumulated unlawful presence, which she seems to have, that's a topic to be discussed with her lawyers, then she may not be entitled to an H4 status. She may be barred for 10 years, etc. But do go ahead and discuss it with lawyers who deal with folks who are not documented. Would porting to EB2 help? Well, that depends on which category is going faster for you. That's a difficult question to answer in the abstract. So normally what I have done in many of our cases is, at one point EB3 was faster than EB2. So even if we have an EB2 approval, we can always file an EB3 I-140. But it's not the same if you have an EB3. You can't file an EB2 I-140. So remember, using the same perm, you could file an EB, on an EB2 perm, you could file an EB3 I-140 and also an EB2 I-140. You could do two I-140s for the same perm. But if the perm is designed for EB3, you cannot do an EB2. You can downgrade, but you can't upgrade. Okay? Moving into management. So if you move into management, chances are H1B amendment would be needed, but I do not know your case, can't really comment. DACA status, H4. I think you're better off you asking these questions of the lawyer who is assisting with DACA. My knowledge is very severely limited. I do not know what your company's policies for immigration are. You can certainly ask. The company's legal team can tell you whether they can or cannot help. So it's a strictly corporate policy question. Not really much to add to this, but if you have a follow-up question, I can try to illustrate. *5. Yeah, my knowledge is quite seriously limited in the cases of undocumented folks. Next question from Styles Kobe is educational background. I passed all my core subjects, English, Math, Science, and Social Studies. 2 electives, failed 2 electives, which I actually don't need. Would I be eligible? I'm not sure eligible for what. What are you asking me? Are you on the phone? If you are, press *5. Styles Kobe. Okay, so this question is incomplete. I have no idea what you're asking me. Sahu77. Subshri says, I recently applied for H4 on my spouse's H1B, only good till July 21st, still waiting for it. Now a new H1B hasn't filed. Oh, you definitely should apply for an H4 extension even while the old one is pending. No question about it. That's standard practice. So even though the old one is not yet adjudicated, you file a second one. Can you apply for an H4 Ead? Well, yeah, absolutely. File for H4 and H4 Ead concurrently. I believe it can be done. Again, I don't do the filings myself, but I'm pretty sure it can be done. *5 if you have a follow-up question. Subshri. *5 if you have a follow-up question. Okay. We go on to the next question. J1 did a master's here and they got a, I don't know, once I get my 212E approved, are you talking about a waiver? If you're on the phone, press *5. Okay, so I'm not sure what you're asking me again. The question is a little unclear. But let's begin from the beginning and see if we can parse this through. So if you have a 212E home residency requirement, you cannot change status within the United States, but you can go and get your F1 visa stamping, even though you have the home residency requirement. Home residency requirement stops you from getting green card and H1L1. It does not stop you from getting O1, F1, etc. visas, or even a B1, B2. Can you start school? And the rule is the same. If you could have started school while on J1, you could start on F1, as far as I know. I don't know what your chances of an F1 are. That's impossible to predict. Definitely it's the mood of the officer who adjudicates your application. It's difficult for me to predict that. *5 if you have a follow-up question. And yes, thank you. You stay safe as well. *5 if you have a follow-up question. Okay. Rajiv Siva. Nice name, Rajiv. L1A is valid till March of 2022. EB1 date is EB1C date is 2018. Concurrent filing for all family members, I-140 approved in 2018. Interview for I-485 was in March of last year. Son is on EAD, employed, protected because of the pending EAD. If I leave the country and abandon my green card, I think he will lose his green card. I don't see what the options are because he's the derivative. Now, I haven't researched again. These are issues. You can always research them. But my first instinct would be no. You're not going to be able to get his green card without getting yours. I see no way to do that. Okay? You should continue your green card. You can convert it to consular. That's not a problem. So you can convert it to consular, and I believe he can continue with his adjustment. Remember, if you tinker with this, he could become subject to an age bar. So make sure whatever you do is properly researched, thoroughly vetted. But yes, there is no way I know of abandoning your green card and having your derivative beneficiary continue his. *5 if you have a follow-up question. *5. Okay. Vena Raga. Current employer filed my H1 extension approved. I did apply H4 extension based on my partner based on this H1. USC has scheduled a fingerprinting session but cancelled due to the pandemic. New employer. Should I apply for another H4 extension based on my future employer's H4? Well, I believe that is the right thing to do, even though this is another one of those tertiary issues where there's no clear policy statement. I don't think there is any conflict. You can always put a cover sheet or a cover letter saying that we have another case pending. So I think you should be okay. But I'm thinking, has the H4 already expired? Are you on the phone? Press *5 if you're on the phone. I have an important question to ask you. Okay, let me just state it for you since you're not here. If your partner's H4 is still valid, applying for another H4 is very easy, no problem at all. But if the old H4 has expired and he or she is currently in the US because of the pending H4 extension, then that extension also needs to be approved in order for another H4 to be approved. So without withdrawing any application, file another H4 extension. And I think that's the smart thing to do. Next question. Laid off on H1B, not sure if my visa is revoked. In case employer revokes the visa anytime after 60 days of last working day, will I get 60 days from the date it is revoked? No. That's 60 days from the date your employment terminates. If I apply for B2, can I come back on the same H1B after exiting and re-entering? I don't know how to answer that question. When you say same H1B, are you saying that you would have the same job back with the old employer? If yes, I think you can, although I'm not quite sure, because if you think about this, see, sometimes we can overthink an issue because we know a lot of law. So I'll give you an example of the way I'm thinking. So H1 requires that the employer has to inform the government when an H1 employee stops working for them. It's required by law. So what if they have not done that? Can you just revive your H1 by going out and coming back in when they were under an obligation to inform, even if they did not? And the answer is, I'm not so sure that the government can't make an issue of it. I think they can, and they could stop you from using that H1 either right at the airport or sometime along the line. So what is the safest thing to do? Just do another H1B when you're ready to get back onto H1B. Star 5 if you have a follow-up question. You said that my apprehension is I file for, yeah, I'll be right with you. My apprehension is if I file for B2 and if this gets approved, this will terminate my H1B, correct? I will not be able to join employer in case my existing visa has not been revoked. Okay, I don't understand that. Let's see, you're here. Let's ask you. Hi, good afternoon, Pennsylvania. Go ahead, please.
Yeah, I just had a follow-up question for him.
Right. Go ahead.
He's actually saying about applying for B2. So may I understand if that's allowed first if your H1B, by anything is terminated because of whatever reason, and if within the 60 days or towards the end of the 60 days, if you're not able to find a job, can you apply for B2 and wait if it's being approved?
Yes, you can. You can wait while it is pending or the time for which you had asked expires. So let's say that you ask for 6 months, which is what you are usually allowed. If you ask for 6 months, you can wait until the case is decided or until the 6 months is passing. Okay.
Oh, okay. Whichever is the first.
Yeah. Yeah. So because if they decide your case in the 7th month, your last month would be illegal.
Right, I understand that. But Rajiv, have you dealt with cases like your B2 has been approved for H1B has, your last job, and especially with this pandemic situation that you might not find a job in 60 days now?
Yeah, we have at least, I can think of at least 10 or 20 people over the last few months who have asked me for advice on converting to B2 because finding a job in such a hurry is not always possible. So yes, there are people in this boat and they're all filing B2s. Okay.
Okay, and do you know that the decision came positive or like?
It's too early. It's too early for me to comment because remember, the COVID emergency was just declared in March, and people are still kind of filing the cases. So I think it'll be a few months till we know for sure. Typical life cycle was approximately 4 to 6 months. Or even more. Sometimes approval of B2 was taking 10, 11 months. So I don't know. I don't have any data yet to tell you, one, how long it's taking, and two, whether people are successful. I can tell you this. I mentioned the most recent lawsuit we filed had a very interesting fact pattern. So what happened was one of our clients' H1B was approved, but it was approved for a duration shorter than what we asked for. And they informed us after that duration had already passed. So today they tell me, oh yeah, we approved your H1, but it expired 10 days ago. Okay. I immediately filed another extension. So now I've been out of status for 10 days. They gave me the second H1 approval and gave it to me for all the way to 2022, but they denied my status saying, oh, well, you are out of status, you have to go outside US. I immediately filed a lawsuit. I said, you put me out of status. I wasn't out of status for any fault of mine. And by the way, and this is where the B2 situation becomes relevant, by the way, you should have exercised your discretion in my favor and ignored, actually it was 43 days, ignored the 43 days out of status because number one, you created it, and number two, these are circumstances beyond my control. So when a situation like B2 presents, we always argue with the government that this is kind of a residuary visa. We don't have a choice. You have to approve it. So I think government recognized that they were incorrectly proceeding. So they told me they have promised by this Friday they will approve my case. So I'll see. Sometimes you just have to go to court over these things. But the point is that what other choice do you have? We don't have any other choice. I can't take a flight out because there are no flights going. I have no choice but to apply for a B2, and these are circumstances which are extraordinary and definitely beyond my control. So I would definitely do a B2, no question in my mind about it. Okay?
Yeah, that's good to know. I think you are a good attorney for such kind of cases. I definitely refer you to my friend.
No, absolutely. The best thing about our firm is because we are located in Washington, D.C. So, and the government lives in Washington, D.C., you can always file a lawsuit against the government in Washington, D.C. Now, there is a chance the government can ask the case to be moved to where you are or where the employer is, but DC courts are not doing that a lot. I hear that very rarely, and I think DC courts are very good with immigration. They've been doing a lot of these cases. They have decided a lot of good cases in favor of the IT industry and the H1B holders. So yes, those are the advantages that we have, and we certainly press them. Why not? So don't think you don't have options. You always have options. Okay?
Okay. So just to understand that, like you said, after within the 60-day period, as long as you apply for the B2 and you wait, and if the decision comes positive, well and good, you still have time. You can find a job, have the new employer file your H1B petition. Obviously, you'll probably have to wait until it's approval now because you have already gone out of H1B status.
Excellent.
Right?
Your understanding is perfect. Yes.
Right. And then in case it was not approved on the day, and you still have the time until unless it was not approved, which would be, like you said, probably 4-6 months, right? Anyway.
Right. So the way this works is unlawful presence in a situation like this works like this. If your case is received by the government within that 60-day grace period, even if they get it on the 59th day, and you can do electronic filing, so it goes online, you are not unlawfully present, you are legal as long as that case is pending. Let's say the case is still pending and you applied for an H1B. If the H1B is approved with the I-94, great. If not, you just have to go outside and get a visa stamping done. Although I would argue for you, as I did for our other client, that, hey, you have to forgive my status issue. These are extraordinary circumstances. Okay. So even people who have even people who have a B2 pending should argue that. They should argue, give me status here. I did not bring COVID into this country. I should be accommodated.
Okay. I see what you mean. So yeah, either case, like you said, worst case, you just have to go out and re-enter with your new H1B petition. Right?
Absolutely. You have to re-enter.
And I guess the old visa
you have
valid because my old, like, let's say, old
yes,
already valid for 2 more years.
Yes, you could enter back with a new H1B approval and the old old H1B visa. Let me rephrase that. I garbled that.
Right.
So if you have a new approval and an old visa, it can still be used. Okay?
That's fairly clear. Thank you so much.
You're welcome. Good luck to you, sir.
Yeah.
Okay, so I'm not sure. Did I cover this? No, I did not. This was Lalit 25 New York. Okay, this is Preeti02. I started working on H4 Ead this June 2020 with company A. They applied for my H1. It got picked. Congratulations. The H1 gets approved. I work for H1B for some time. Can I switch back to H4 Ead? Yes, you can. What is the procedure? Exactly the same procedure as it was the first time around. You'll have to apply for change of status and EAD again. If I just use, let's say, a year on this approved H1B and switch back to H4 Ead and continue working, will it save the rest of my 5 years of H1B? Yes, it does. Yes. You will save your H1 if you convert back to H4. Considering the H1B gets approved and I utilize the tenure, once the time for extension comes, if it gets denied, can I switch back to H4? So yeah, if you've been on 6 years of H1B, you still can switch back to H4 Ead. No question about it. Star 5 if you have a follow-up question. Star 5. Okay. Let's see. This is not sure. 571, I think Pennsylvania. 571, where are you calling from?
Hi, Rajiv. This is Preeti calling from Virginia.
Yes, ma'am.
Yes, so thank you so much for taking your time and answering questions, sir.
Absolutely.
So my question is about like when I am switching from H1 to H4 Ead or H4 to H1. So for both these situations, can I like switch among these two while staying in US itself? Or do I have to go outside the country for any of the situations?
You can switch one from the other within the United States, Preeti.
You mean I don't have to go, because like if I am on H1 and let's say another extension time comes and it gets denied, so
that's a different question.
At that point.
That's a different question.
Okay.
If you are maintaining status, you can switch one from the other. If you're out of status, you cannot.
Okay. So the first part of the question, like I am on H1 and I use like let's say 1 year and I have to switch to H4, so I just apply for another H4 like I applied for the first time.
Yes.
That is the same application, right?
Yes, ma'am.
Okay. So like when considering my H1 gets approved for the first time, so the H4 Ead that I hold now, does that remain invalid then?
It becomes invalid once you have obtained H1B change of status.
So I automatically like change to the H1 work authorization.
You do.
I don't have to do anything.
You do. Yes.
Explicitly about it.
Yes. When you apply for change of status, it's an automatic change. Okay.
Okay. Got this point. So how about the next thing? Like if like I use for the tenure that the H1 was approved for, and then let's say I apply extension after the 1 use of this H1 and it gets denied. Then when I'm in US, I'm like out of status at that point.
You have to go outside USA.
Back to H4 Ead.
You have to go outside USA, get your H4 visa stamp, come back and apply for an EAD.
And like anything that happens that I'm not able to go out, so can I also apply for B1, B2 kind of thing?
B1, B2 does not work if you're out of status.
Okay. I mean, like just taking in a hypothetical situation, like the situation is like right now.
Preeti, listen.
The COVID situation where people are not able to travel.
Yeah.
So let's
hang on. Let me make one thing very clear. Okay. Hypothetical situations are used to write books, not to address questions. I can write maybe a multi-volume book on the possibilities. The practical advice for people is this. File for your B2 while you are still in H1 or H4 status. Now, I have cases where somebody has a particular immune system problem He cannot travel. His H1 was denied. He came to me about 3 months after the H1B was denied. And I said, look, you are in a bad situation. You are running unlawful presence, but apply for a B1, B2. Ask the government. And he had, I think, booked a flight for January or February, and that flight got cancelled. So I said, produce evidence that you tried to leave the country. Ask the government as a part of the B1, B2 that please restore my status within the United States. Forgive my unlawful presence because it is circumstances beyond my control. However, just because he filed a B1, B2 does not stop the running of unlawful presence. He is still unlawfully present until the government excuses him, which they may or may not. Therefore, it is not safe to depend upon a B1, B2 if you are already out of status when you apply. Okay?
Okay. That makes sense. Yeah. I got the gist of it.
Yeah. Even if you're out of status for 1 day, your unlawful presence has started, and now you are stuck with depending upon the mercy of the government. Okay?
Right. Okay. Yeah. Thank you so much.
You're welcome, Jay. Good luck. Irfan 19. I have a green card based EAD card and H1B. So I assume you're talking about 485, Irfan. I got a new job planning to join on EAD. Does it revoke my H1B status? I've said this before. The best way I can say it, your H1B goes to sleep. So let's say you're working for IBM. You are on 485, but you've not used your EAD. You are using your H1B. Working for IBM itself, you start using your EAD for whatever reason, and your H1B is still valid for another couple of years. If you want to go back from EAD to H1B and you're working for the same company, no amendment, etc. is needed, all you have to do is go outside USA and come back in with an H1B visa. Now you are back on H1B from EAD, but you do have to step outside USA and come back with a visa. Okay. Now, if your green card application is denied, can you come back on H1B? And the answer is sure, if you still have time remaining on your 6 years, on your first 6 years. If you are getting extensions beyond 6 years based upon a green card, I-140, then I don't know. It depends. If the denial is of the I-140, while the appeal is pending, you can keep getting H1B extensions. But if the denial is of the 485, no extension. *5 if you have a follow-up question. *5. Okay. Folks, I'm not going to have time for new questions. We are past 1:30 and I'm still dealing with the posted questions. So unfortunately, I won't have time for new questions today. scoil.libra. My in-laws are here on B1, applying for their extension. Is this extension a one-time thing, or can we apply another one? You can apply for another one. If the visa extension is denied, okay, I'm not sure what that means. You're not asking for a visa extension. You're asking for stay or status extension. Okay? Yeah, sorry guys, I won't be able to answer new questions. Okay. So, if the extension is timely filed and then it is denied, then unlawful presence begins to run from the date of the denial. My wife is on H4 Ead, got laid off. Is she allowed to file for unemployment benefits? And the answer is yes. If she was working, nothing stops her from applying for unemployment benefits, and I don't think it's a public charge issue. Next question, H1B lottery 2014 got approved. She left USA before October 1st. So she never really got an H1B change of status or an H1B visa. Can she reuse H1B of 2014? And the answer is, well, she can try. There's no harm in trying. I'm not sure government, because USCIS has said at various times, they don't consider people to be exempt from the quota until they have either received a change of status or a visa stamping. I think it's an incorrect interpretation of the law, but that's what they have said. However, as a practical matter, people in your wife's situations, we've been able to get them H1B approval so far, even though they never got a change of status or visa stamping. *5 if you have a follow-up question. *5. Okay. Let's see. This one is from area code 412. 412, where are you calling from?
Hi, we are calling from Los Angeles, California.
Yes, ma'am. Go ahead.
Yeah. So for my first question, like my in-laws are here on B1 visitor visa, and we were planning to apply for their extension. So we basically want to ask here, like this. We heard like in your whole span of time, you can only get one-time extension of 6 months. So is it actually right, or
that is incorrect? That is incorrect. Next question.
Okay. And if we'll do this 6 months extension, I mean the stay extension, and in meanwhile, like the stay extension got denied for any reason. So will this have like the complete visa? Like if we still have 2 months.
Ma'am, that question actually, hang on. I don't have time to discuss everything that you're asking. I can tell you this: if the status is denied, they should leave the United States. Okay.
Okay, I got it.
All right.
Okay, and for my another question, like for H4 Ead for unemployment benefits, we heard like if someone on a visa takes these unemployment
benefits, stop. I've already answered that question. In my view, unemployment is not a public charge issue. Next question.
Okay. Yeah, that's okay.
Good luck.
And this thing, like we can reuse the approved H1 of 2014, even if it is like revoked, because we don't know if our employer has already revoked that time or not.
You can. It's a good question. I think if it is revoked before October 1st, not I think, I know. If it is revoked before October 1st of that year, you certainly can't use it. But if it is revoked after October 1st, you can argue that you're exempt from the quota. I don't know if you would win, but it's worth a shot.
Oh.
Okay.
Okay, I got it. Yeah, thank you so very much.
You're welcome. You're welcome. Good luck. Well, as Goel Libra, I'm going to have to skip this question. There are too many of them from you. So I actually am running short of time as well. We'll talk about this next week. Or 2 weeks from now. Then the next one is member 24. Thanks for hosting free public forum. I'm on H1B, valid till September 2021, with my amendment being filed as a changed location. Green card labor is in progress. My spouse is also on H1B. Is it advisable for me to continue my H1B green card process? Oh yeah, but you realize that even if you switch to H4 Ead, your green card can still go on. Green card doesn't require you to be on H1B. Yeah, so that I think answers your questions. Just go for an H4 Ead and continue your green card. Okay? *5 if you have a follow-up question. *5. Okay, so this one these two we've already dealt with. All right, but you know what? There's only a few people left now. Let's see if we can help somebody else. Go ahead. Any question, guys? Press *5. Any question? Press *5. Let's see if there's somebody we can help. Okay, there's only one question. That's easy. Okay, let's do this question. Pennsylvania. Go ahead.
Hi, Rajiv.
Yeah.
Hi, Rajiv. This is Brijesh.
Yes, Brijesh.
I have a question on the nationalization process.
I have two questions. The first question is regarding my wife's naturalization process. My wife, we are now eligible to file the naturalization application.
Right.
And in the last 5 years, my wife has been outside of United States for 572 days.
Okay.
And just once, she has been over 6 months, but less than 1 year. So at least, to be precise, it's 197 days. Okay. So will there be any issue when we file for naturalization?
Yes.
Valid documentation?
Yes. The Trump administration is trying to block as many naturalizations as they can. Okay. So when you have over 6 months, under a year, we have to look at the overall case. So let me give you an example of a good case. A good case is where you are gone for a particular reason, and that reason unexpectedly took more than 6 months. In the meantime, your family continued to stay in the United States. You had a home in the United States, and you came back as soon as your purpose was finished without just living in India needlessly. So these are all good circumstances. What I would recommend, Brajesh, is that talk to a local lawyer, even though I can help you, but I won't be able to go to the interview with you. So if you want somebody to go to the naturalization interview, talk to a local lawyer. This is not rocket science, but you need somebody to take a look at your case and see if you have a good enough explanation for those absences. Okay. If you don't, wait till November. Let me see what happens with whether Trump wins again, God forbid, or we have a new administration, in which case I think the naturalization policies become more relaxed.
Right. Okay. So my second question is, I was employed with an employer X who filed my green card, and I got my green card, let's say on June 1st, and June 30th my employer says I don't have a job for you. So in that case, does that impact my naturalization process?
Okay, sorry, I lost track of what you just asked me. I got a text from somebody. You said you got your green card approval. Did you leave the employer? Sorry, I didn't catch that part.
Basically, I was working for employer X,
right?
And who filed my green card. I get the green card on June 1st, for example. I'm just giving you an example.
Right.
And then on June 30th, my employer tells me that I don't have any job for you, right? So within 30 days,
there are two things going for you. One, you did work for the same employer. Even if you worked with them for 1 day, I have a strong argument that he worked for them for 1 day after getting his green card. Okay. Second is that you didn't leave, your employer didn't have work for you.
Correct.
Okay. So those two things I think are sufficiently protective. Can this be challenged anyway? The government would want to know. Sure. Are they going to be able to push their way through to a denial based upon that ground? No. I think you're fine.
Okay, perfect.
Okay.
Thank you so much.
You're very welcome. Good luck, Brajesh. Folks, as always, I consider it a privilege to be able to talk with you every 2 weeks. I'll see you again in 2 weeks. Be well, everyone. Stay safe. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.